So there's an important development in a lawsuit which aims to remove a state ban on the purchase and possession of suppressors. So let's talk about this. But before we jump into this suppressor ban challenge, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market, and if you're looking for an EDC knife, I highly recommend Kershaw Knives. Kershaw Knives recently dropped their new 2023 line of knives, and I carry one of their knives every single day for my EDC, and I cannot recommend them enough. And right now, if you go to their website and you use the code 23scholar20, you can get 20% off of your order and free shipping on orders of $100 or more. So head on over to Kershaw Knives, use that code, and pick yourself up a quality EDC knife. As I mentioned in the intro, in this video, we will be discussing a lawsuit which aims to remove a state ban on the purchase and possession of suppressors. The case we will be talking about in this video is called Anderson v. Raoul. This is a lawsuit filed in the Southern District of Illinois, and it aims to remove the state of Illinois ban on the purchase and possession of suppressors. This case is very important because although 42 states allow for the ownership of suppressors, the purchase and possession of suppressors, there are 9 jurisdictions which do not. Those 9 jurisdictions include California, Delaware, the District of Columbia, Hawaii, Illinois, Massachusetts, New York, New Jersey, and Rhode Island. This case had prior been put on hold until Judge McGlynn ruled in a different case which challenged the Illinois state ban on the purchase and possession of assault weapons or so-called assault weapons in magazines that hold more than 10 or 15 rounds. That case was the Barnett case. Well, as many of you know, Judge McGlynn recently issued a decision in that case granting a preliminary injunction against the PIC Act, and the PIC Act was that ban on so-called assault weapons and magazines. Now, that case is currently up before the 7th Circuit, but that decision by Judge McGlynn at the district court level is now being used to once again start the suppressor lawsuit, and the strong language in that case means that the state of Illinois' prior arguments for why they can ban suppressors is now significantly weakened. Now, this suppressor lawsuit uses the Supreme Court's recent ruling in New York State Rifle and Pistol Association versus Bruin to attack the state's ban on the purchase and possession and ownership of suppressors. In Bruin, the Supreme Court issued an opinion authored by Justice Thomas, which struck down New York's May issue CCW licensing scheme, and he found that it was inconsistent with this nation's history and tradition. One of the primary findings of the Bruin decision was that the government bears a burden to prove that their restrictions are based in the history and tradition of our nation. This lawsuit, this suppressor lawsuit, aims to finally make a state explain why their outright ban on the purchase, sale, and possession of suppressors is consistent with Heller and now also Bruin. In this lawsuit, the plaintiff stated that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are, therefore, neither dangerous nor unusual and cannot be banned. This is important because it's well established now that modern arms are protected under the Second Amendment, and not just muskets like you'll hear some people on the anti-gun side argue for quite often. They try to limit the type of arms that are protected to those that existed during 1791. In the legal world, that type of argument just simply has no more strength, but you still have states like Illinois try to put forward those arguments, try to put forward some sort of restriction on the Second Amendment, or they try to claim these types of accessories or these types of arms are not protected by the text of the Second Amendment. When in fact, the Supreme Court reiterated in Bruin that we have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communication, and the Fourth Amendment applies to modern forms of search, the Second Amendment extends, prima facie, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, that general definition covers modern instruments that facilitate armed self-defense. So that argument that suppressors are not protected since they did not exist during the founding is irrelevant, and also the attempt to try to frame them as not arms that are protected by the Texas Second Amendment really also has no weight. And they argued, therefore, under Heller and Bruin, a state like Illinois cannot completely ban the keeping and bearing of suppressors. Illinois here is completely banning the use and possession of these protected arms, these suppressors, which again at a federal level is legal to purchase and possess, but the state has gone beyond that and has completely banned those items. Now, the judge in the suppressor case recently stayed this case for 90 days because other lawsuits were currently going on which challenged the state of Illinois' ban on so-called assault weapons and magazines. The judge held the suppressor case from proceeding forward because he believed something maybe in the Barnett case or one of these other lawsuits would impact what's going on right now in the suppressor lawsuit. And in the recent Barnett ruling, there was in fact strong language which cuts against the state of Illinois' arguments that suppressors are not arms, that they're not protected by the Second Amendment, and therefore they can outright ban them. In the Barnett decision, Judge McGlynn discussed whether the PIC Act's regulation of accessories like magazines, flash hiders, and pistol grips, and also pistol braces, which was interesting that he included that, implicated arms protected by the text of the Second Amendment. Ultimately, he found that yes, it did. In that decision, he stated, "This court will first address defendant's contention that non-essential accessories are not within the scope of the Second Amendment's plain text. The PIC Act outlaws possession of semi-automatic pistols with a detachable magazine if it is equipped with any of the following: a threaded barrel, a shroud attached to the barrel, or that partially or completely encircles the barrel, a flash suppressor, or arm brace. Defendants contend that such items are not necessary to the functioning of a firearm and are thus not arms and therefore not protected by the text of the Second Amendment. Defendant's argument is not persuasive. The Seventh Circuit has recognized the Second Amendment as extending to corollaries to the meaningful exercise of the core right to possess firearms for self-defense. He then concludes by saying, therefore, because the meaningful exercise of the right to armed self-defense is wholly dependent on the ability of citizens to utilize their arms and hit their intended target, items that aid in accuracy may be considered arms and are presumptively protected by the text of the Second Amendment." So in the Barnett decision, Judge McGlynn found that the accessories which are banned from being used under the PIC Act are necessary for the meaningful exercise of the right to armed self-defense, and therefore they must be considered as arms and presumptively protected by the Second Amendment. The state's outright ban on their use and how those accessories can be used on specific firearms as a result is unconstitutional. That was part of the rationale in the Barnett case that is very important for how this suppressor lawsuit moves forward. As I mentioned in the Anderson suppressor lawsuit case, it was on hold for this decision out of Judge McGlynn. And one of the important things we got out of the Barnett case is the clarification that these types of accessories are clearly protected by the Second Amendment. We all knew that fact, but now you finally have a district court here in Illinois stating that fact very clearly and also finding that a state's ban on the use of these types of accessories is unconstitutional. The plaintiffs in the Anderson lawsuit are now requesting that this case be removed from its current stay and that it proceed forward in light of that Barnett decision. The plaintiffs now have plenty of support in their own jurisdiction in the state of Illinois in federal courts for what accessories like suppressors are clearly protected by the text of the Second Amendment, how accessories are arms despite what the state of Illinois tries to argue. Also, importantly, all the historical support that the state of Illinois put forward to ban other types of accessories like flash hiders, pistol grips, barrel shrouds, all those other items was rejected already in federal court. And the hope is that if the state tries to use that same type of historical argument to justify their suppressor ban, the court will just need to look at Barnett and see that, hey, those types of historical evidence, that type of historical support is not sufficient enough to actually support this regulation or this ban on these types of accessories. So this is a case we will definitely be keeping our eyes on. The suppressor lawsuit in Illinois will once again start moving forward, but with additional legal support, which is really good and really supports why the suppressor ban is 100% unconstitutional. But if we learn any more about this case going forward, I will let you all know. And also, if you want to learn more about what's going on with the two-way world, you can watch these videos here on the screen. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.